Mr. President, distinguished members of the Court, it is my great honour and privilege to appear on behalf of Egypt, of the Arab Republic of Egypt, in this advisory opinion of historical importance, in which the General Assembly is once again seeking the Court's guidance in respect of the question of Palestine. This comes against the backdrop of a 75-year history of displacement, dispossession, collective punishment, and daily, indiscriminate and systematic violence and human suffering of untold proportions. Mr. President, as we speak, Israel's brutal onslaught continues to rage in occupied Gaza, where 29,000 innocent civilians have been killed and almost 2.3 million people forcibly transferred and displaced in violation of international law. Israel is deliberately and wantonly creating conditions of life that are intended to make life in Gaza impossible, imposing siege and starvation, including by impeding humanitarian access and the distribution of relief through constant obstruction and bombardment. With the impending attack on Rafah, where 1.4 million people have sought refuge, Israel is continuing its policy of mass forcible expulsion of Palestinian civilians, all while the Security Council repeatedly fails to call for a ceasefire in callous disregard for Palestinian life. Simultaneously, Israel is continuing its illegal practices in the West Bank, scaling up attacks, access restrictions, punitive house demolitions, and supporting settler violence that has displaced entire communities. Increased settlement activity continues to erode the basis for a two-state solution, dimming prospects for a lasting peace in the region. These ongoing, grave violations of international law by Israel, the occupying power, are part of a wider policy that seeks to dispossess the Palestinians of their land and assert Israeli sovereignty over it. This is manifestly illegal and renders the occupation as a whole unlawful. It is shocking that at this critical moment, some states would rather see this court abscond its responsibility as the principal judicial organ of the United Nations by declining to render this advisory opinion. What message does this send about these states' respect for international justice and the rule of law? Mr. President, I will focus my statement on four main points, namely, number one, the Court's jurisdiction and competence, the legal framework for assessing Israel's prolonged and illegal occupation, which violates non-derogable principles of international law, the purported justifications of self-defense or military necessity, and finally, I will conclude on the legal consequences and a summary of Egypt's submissions. First, on the matter of jurisdiction and competence, the small number of states objecting to the Court's exercise of jurisdiction have variously argued that the request is politically motivated, instrumentalizes the Court, circumvents the consent of Israel, covers too vast a scope, or will prejudice the peace process and negotiations between the parties. Let me recall that the Court has repeatedly and consistently rejected such arguments. In the Kosovo advisory opinion, the Court did not concern itself with the motives which may have inspired the request or the political implications of its opinion. Since the General Assembly is duly authorized under Article 96(1) of the UN Charter and brought forth its request through a validly adopted resolution, the request, in the Court's own words, in principle, should not be refused. In the nuclear weapons and Chagos advisory opinions, the Court refused to second-guess the decision of the General Assembly, stating that it has the right to decide for itself on the usefulness of an opinion in light of its own needs. Distinguished members of the Court, the General Assembly has turned to this august Court with what is manifestly a legal question, seeking a legal answer that would indisputably assist in discharging its functions. Allow me to recall that this very Court, in the Wall opinion, affirmed the UN's permanent responsibility for the question of Palestine until such time as it may be resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. In the Wall opinion, the Court found no merit in the proposition, echoed by some in these proceedings, that the ongoing negotiations constituted a compelling reason to decline its competence. It reached a similar conclusion in the Nuclear Weapons Advisory Opinion after noting that its opinion would have relevance for the continuing debate on the matter in the General Assembly and would present an additional element on the matter. Indeed, rather than prejudicing the peace process, the present advisory opinion serves not just as an additional element, but rather an essential one for the General Assembly to continue to carry out its role in relation to the Palestinian-Israeli conflict. This is absolutely critical, given the complete absence of any real prospect for a peaceful solution. The Court could not possibly turn its back on this wealth of jurisprudence or disregard the many compelling reasons for it to honour the General Assembly's request. As summarized so aptly by the representative of Palestine, the Middle East region yearns for peace and stability and a just, comprehensive and lasting resolution to the Palestinian-Israeli conflict based on the principles of international law and the establishment of a viable Palestinian state on the pre-1967 lines, with East Jerusalem as its capital. The legal determination by the Court in the present advisory opinion is indispensable to guide the General Assembly and the international community to achieve this objective. Second, Mr. President, I turn to the question of the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967. Distinguished members of the Court, Palestine has been subjected to the longest protracted state of occupation in modern history, as well as de facto and de jure annexation that confirm the unlawful nature of the occupation. Israel's persistent policy of implanting settlements in the West Bank and occupied Jerusalem for the purpose of creating facts on the ground and breaking up the territorial contiguity of the occupied territories is a blatant disregard for international law. 20 years ago, the representatives of the State of Palestine laid before this Court the facts of Israel's intensive settlement and colonization policy, which had, at the time, transferred 400,000 illegal settlers to the occupied Palestinian territories. Today, that number stands at 750,000, deliberately and permanently altering the status of the occupied territories. In addition to the policy of de facto annexation, Israel purported to annex East Jerusalem de jure through the basic law adopted by the Israeli Knesset in 1980, stipulating Jerusalem, complete and united, is the capital of Israel. The very limited number of states defending these policies advance two principal claims, namely that the legal status of occupation does not change if the occupation is prolonged or involves illegal violations of jus in bello, and that under jus ad bellum, Israeli occupation is lawful since, inter alia, relevant UN Security Council resolutions did not declare otherwise. Egypt submits that the proposition that occupation is merely a de facto situation whose legality cannot be called into question is seriously flawed. As highlighted by a number of participants, the legality of an occupation must be assessed by reference to the UN Charter and general international law. In fact, Israel's prolonged occupation violates a number of distinct legal regimes that exist and operate simultaneously and concurrently. These include, number one, the law of occupation, part of the jus in bello that was characterized by this Court as intransgressible. Number two, the jus ad bellum, and the peremptory prohibition of the acquisition of territory through force. Number three, the principle of self-determination, also a peremptory norm of international law, described by this Court as erga omnes and irreproachable in the East Timor case. and 4, the fundamental prohibition of racial discrimination, segregation, and subjugation. It is against this legal framework that the legality of Israel's policies and practices in the occupied Palestinian territories must be assessed. First, with respect to the jus in bello, it is a fundamental principle of international law that an occupying power is prohibited from changing the status of the occupied territory, as well as its annexation in whole or in part. It is only entitled to exercise limited powers intended to be temporary in nature, with the aim of balancing between its own military needs and the protection of the local inhabitants. These are not rights bestowed on the occupying power, but rather limitations on its authority. It flows from this that belligerent occupation is governed by 2 key principles. First, it is a temporary regime, and second, it cannot transfer sovereignty to the occupying power. Rather, it freezes the legal order of the occupied territory throughout the duration of the occupation. The occupying authority is merely a de facto administrator, a principle intended to protect both the inhabitants of the occupied territory as well as the separate existence of the state, its institutions, and its laws. This is reflected in Article 47 of the 4th Geneva Convention, and is precisely what distinguishes occupation from annexation. The prohibition of permanently changing the occupied territory extends also to its demographic component. Article 49 of the 4th Convention prohibits individual or mass forcible transfer of civilians outside the occupied territory and the transfer by the occupying power of parts of its own civilian population into the territory it occupies. According to the 1958 commentary, this was intended to prevent a practice adopted during the Second World War by certain powers, which transferred portions of their own populations into occupied territory for political and racial reasons and in order, as they claimed, to colonize those territories. As demonstrated in Palestine's statement, there is overwhelming evidence that Israeli support for and maintenance of settlements is intended to permanently alter the demographic composition of the occupied Palestinian territory and extend Israeli sovereignty over it. This is coupled with Israel's mass forcible transfer and forced displacement of the Palestinians in Gaza through its illegal evacuation orders and indiscriminate use of force, which has been labeled by the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territory as ethnic cleansing. It should be highlighted that Article 49 not only prohibits forced transfers, but also, in the court's own words, and I quote, any measures taken by an occupying power in order to organize or encourage transfers of parts of its own population into the occupied territory. Numerous resolutions of the General Assembly and Security Council affirmed the illegality of Israel's settlements, annexation, and measures altering the demographic composition, character, and status of the Holy City of Jerusalem, considering them invalid and a flagrant violation of the 4th Convention, while requiring Israel to desist from such practices. Security Council Resolution 298 stated, and I quote, all legislative and administrative actions taken by Israel to change the status of the City of Jerusalem, including expropriation of land and properties, transfer of population, and legislation aimed at the incorporation of the occupied section, are totally invalid and cannot change that status. The Council also declared in relation to Jerusalem in Resolution 478 of 1980 that Israeli legislative and administrative measures are null and void and must be rescinded forthwith. Israel remains in defiance of these and subsequent resolutions, including Resolution 2334 of 2016 and numerous General Assembly resolutions, in addition to the provisions of the Geneva Conventions previously described. Israel's prolonged military rule and its strategic settlement policy, considered a national value under Israeli legislation, is essentially a systemic de-Palestinianization of the occupied territory, including Jerusalem, intended to permanently change its demographic characteristics and enhance its Jewish component, thereby achieving the de jure and de facto annexation of that territory. This leads to the conclusion that Israeli occupation is, in fact, an illegal annexation, conquest, and de facto colonial endeavor. Mr. President, the second legal principle by which the legality of Israel's occupation is to be assessed is Article 2.4 of the UN Charter, which prohibits the acquisition of territory through force, one of the most fundamental principles of the post-UN Charter era. The vast majority of states participating in these proceedings submit that Israeli occupation, by virtue of its permanence, de jure and de facto annexation, manifestly violates the principle of inadmissibility of acquiring territory through force. Only one state has attempted to justify Israel's actions by contesting the Palestinians' title to the occupied territories and justifying Israel's territorial expansion as the product of a defensive war. Egypt submits that these claims have no basis in fact or in law, and seek to derail the court by raising issues outside the temporal scope of this request. They are reminiscent of the archaic international law of the 19th century that justified territorial conquest through denying the sovereign status of colonized peoples, relegating them to the realm of terra nullius. There is also no support for the proposition that Israel was acting defensively in 1967. International law recognizes neither preemptive nor preventive self-defense, and the terms of the UN Charter on this matter are clear, requiring an armed attack to occur in order to trigger the right of self-defense. Israel's attack in 1967 was therefore not a defensive but an aggressive war. Even if the claim of self-defense were valid, which clearly is not the case, a decades-long occupation is not reconcilable with the customary international law conditions of necessity, immediacy, and proportionality. In any event, the issue is a moot one, as it is universally recognized that a state may not gain title to territory through any use of force, regardless of its purported legitimacy. These claims also find no basis in Security Council Resolution 242, which unequivocally recognized the inadmissibility of acquiring territory through force, demanding Israel's withdrawal from territories occupied in the recent conflict, and emphasizing the duty of all states to act in accordance with Article 2.4 of the Charter. Resolution 242 was reaffirmed by Resolution 338, while the inadmissibility of territorial acquisition through force was confirmed in at least 9 subsequent Security Council resolutions. In fact, Resolution 471 clearly stated, as far back as 1980, the overriding necessity to end the prolonged occupation of the Arab territories occupied by Israel since 1967, including Jerusalem. In Egypt's view, it is clear that under international law, the territorial status of the West Bank, including Jerusalem and the Gaza Strip, cannot lawfully be altered through armed conflict. Israel's protracted occupation, which is coupled with measures to permanently change the demographic characteristics of the occupied territory and annex part of the land de facto and de jure in violation of the cardinal principle of the prohibition of the acquisition of territory through force, is therefore illegal per se and an ongoing violation of international law. Distinguished members of the Court, The third legal principle against which Israel's conduct must be assessed is self-determination. Egypt submits that Israel's indefinite occupation amounts to a nullification and denial of the Palestinian people's inalienable right to self-determination. It is indisputable that this right, enshrined in Article 1(2) of the UN Charter and both human rights covenants, is a cardinal principle in modern international law. Its erga omnes character, confirmed by the court in the East Timor case, entails that all states and international organizations have a legal interest and a duty in respecting and protecting this right. This court already affirmed in the Wall Advisory Opinion the applicability of this right to the Palestinian people. Mr. President, Israel's indefinite occupation of the Palestinian territories is, as a whole, inconsistent with the principle of self-determination and breaches three salient aspects of this principle. First, it obstructs the Palestinian people from freely determining their political status, achieving independent statehood, sovereignty, and the right of return. Second, it deprives Palestinians of their right to pursue their economic, social, and cultural development. In gross breach of international law, Israel restricts Palestinians' access to Jerusalem's Christian and Muslim holy sites, notably Al-Aqsa Mosque, wantonly depletes Palestinian natural resources, imposes access restrictions to Area C, and obstructs the movement of goods and people between the West Bank and Gaza, stunting Palestine's economy and impeding the geographical unity of the State of Palestine. Third, the fragmentation and dismemberment of the occupied territories through Israel's settlements policy, the wall, and measures of de facto and de jure annexation are a blatant violation of the fundamental principle of the integrity of the self-determination unit. The territorial unit of Palestine includes both the West Bank, including the holy city of Jerusalem, and the Gaza Strip. Although Israel withdrew its forces from Gaza in 2005, it still retains effective control by, inter alia, exercising complete control over Gaza's airspace and territorial waters, the flow of people and goods in and out of Gaza, the Palestinian population registry, the tax policy, and transfer of tax revenues. Israel's continuing military incursions into Gaza, including the ongoing brutal assault, indicate Israel's continuing authority over the territory. Together, the West Bank and Gaza constitute a single territorial unit. This has been confirmed by numerous Security Council resolutions which refer to Gaza as an integral part of the territory occupied in 1967 and of the Palestinian state under the two-state solution. Egypt firmly denounces the ongoing obstruction of the Palestinian people's inalienable, permanent, and unqualified right to self-determination, a violation as argued by Palestine that is an essential feature of Israel's prolonged occupation. One only needs to look at Israel's vicious, wholesale destruction of Gaza today, after years of imposing the medieval methods of siege and blockade, to realize the extent of Israel's transgression of this principle. Israel's prolonged occupation is therefore illegal per se, and is an ongoing internationally wrongful act that must be immediately brought to an end by Israel by immediately ending the occupation. The fourth legal principle against which Israel's conduct must be assessed is the fundamental prohibition of racial discrimination, segregation, and subjugation. On a daily basis under occupation, Palestinians face institutionalized discrimination and segregation under a dual legal system applying different laws to Palestinians and Israelis. Israeli military orders in the occupied territories entrench racial discrimination between Palestinians and Israeli settlers. Israel also implements de facto and de jure measures of racial discrimination, including in the areas of detention, criminal justice, housing, land confiscations, and house demolitions. How can such practices, which have been described by a number of participants as crimes against humanity, how can they be consistent with any notion of human rights and human dignity in the 21st century? Israel is under an obligation to repeal all such legislation that maintains its systematic, oppressive and institutionalized policy of racial discrimination and segregation against the Palestinian people, and to cease all discriminatory policies and practices. I now turn to whether self-defense or military necessity may justify Israel's prolonged occupation. The argument that a state may exercise self-defense against a territory under its own military occupation and effective control is counterintuitive, particularly since the occupying state has the authority and even the obligation to ensure public order and safety in the occupied territory. In the Wall advisory opinion, this court found that Article 51 of the Charter, which recognizes the inherent right of self-defense, had no relevance, as the acts invoked by Israel were acts arising out of the occupied Palestinian territory, which is under Israeli effective control and not imputable to another state. Egypt finds no reason for the court to depart from this considered opinion in the current proceedings. The court also rejected the justification of military necessity. The modern conception of military necessity is strictly limited to the contexts in which it is expressly recognized. It is thus already considered in the formulation of the obligations set out in humanitarian conventions, some of which expressly exclude reliance on military necessity. For example, no military necessity qualification is permitted under Article 49, paragraph 6 of the Fourth Geneva Convention, which prohibits the transfer of any part of the occupying power's civilian population into an occupied territory. This cannot be justified as a safety measure taken by Israel in the exercise of its prerogatives as an occupying power. According to the legal maxim, ex injuria jus non oritur, one should not be able to profit from one's own wrongdoing. Israel thus cannot invoke self-defense to maintain a situation created by its own illegal conduct, or to justify violations of peremptory norms of international law. Distinguished members of the court, for how much longer do the Palestinian people need to wait before they are able to exercise their legitimate rights under international law? For how much longer will the United Nations continue to manage the humanitarian impacts of Israeli violations without addressing their root cause? History will judge us for how we respond today. Egypt respectfully submits that the court should advise the General Assembly that, number one, the prolonged Israeli occupation is, per se, a continuing violation of international law for its breach of, number one, the jus in bello, number two, the prohibition of the acquisition of territory through force, number three, the right to self-determination of the Palestinian people, and number four, the prohibition of racial discrimination, segregation, and subjugation. Second, Israel, as the wrongdoing state, is obliged to make full reparation through restitution, compensation, and satisfaction, either singly or in combination, by ceasing immediately and unconditionally its unlawful occupation of Palestinian territory and rescinding the associated unlawful policies and practices of annexation, settlements, and discriminatory legislation. Three, all states have a duty not to recognize the illegal situation created by Israel's ongoing violation, resulting from its prolonged occupation, settlement, and annexation of the occupied territory, and not to render aid or assistance in maintaining that situation. Mr. President, the consequences of Israel's prolonged occupation are clear, and there can be no peace, no security, no stability, no prosperity in the Middle East without upholding justice and the rule of law for the Palestinian people. I thank you.